This comes after the U.S. Supreme Court struck down New York's restrictive handgun laws, which required a good reason to carry.
The Supreme Court today said you can't require someone to justify why they want to conceal carry a gun, but it was leaving open,
in effect, banning, or at a minimum, severely restricting
justify gun laws going forward and will lead to courts striking down a wide variety of gun safety laws.
New York lawmakers have approved a sweeping overhaul of the state's handgun licensing rules.
Really made America a very dangerous place, particularly in New York City.
The Supreme Court is once again in charge of the concealed carry ban problem, and they must decide whether to overturn the legislation imposed by all of these states and the several states that directly follow the court's ruling in the Bruen case. New York's concealed carry law. The issue of concealed carry and related bans and laws, which were passed in direct response to the Second Amendment and the Bruen decision, is once again back in the hands of the Supreme Court. Recently, 5 cases had expedited hearings in the Second Circuit because of a recent warning the Supreme Court issued to the Second Circuit about adhering to what they stated in Bruen. These 5 cases challenged New York's new Concealed Carry Improvement Act. The New York law created a hyper-restrictive concealed carry regulation in direct response to the Supreme Court's ruling in Bruen.
This comes after the U.S. Supreme Court struck down New York's restrictive handgun laws, which required a good reason to carry.
Parts of a New York gun law that puts restrictions on carrying a concealed firearm.
The Supreme Court today said you can't require someone to justify why they want to conceal carry a gun, but it was leaving open.
Remember, the court has ducked this question of guns outside the home for 14 years.
Justify gun laws going forward and will lead to courts striking down a wide variety of gun safety laws.
The state of New York passed this new law just 8 days after the Supreme Court issued a 6-3 decision. Now, the Supreme Court will gather to consider whether they will address this issue and potentially strike down New York's defiance. They will hold a conference at the beginning of next month. For those unfamiliar, in Bruen, the Supreme Court struck down New York's original may-issue CCW licensing scheme, finding it inconsistent with the nation's history and tradition. One of the primary findings of the Bruen decision was that the government bears the burden of proving that their restrictions are based on the history and tradition of the nation. Another important point in the Bruen opinion was that a state like New York cannot simply designate an entire state or area as a sensitive location. Justice Thomas specifically mentioned that New York could not make the entire island of Manhattan a sensitive location. However, despite that decision, just 8 days after the Bruen ruling, New York passed the CCIA, which made the situation even worse than before Bruen. This law was challenged in multiple district courts, and some of these courts granted preliminary injunctions that halted the enforcement of the CCIA. The state of New York then appealed to the Second Circuit, which is very anti-arm. In some cases, the Second Circuit granted blanket stays on those lower court decisions. In response, the Gun Owners of America originally sought emergency review from the Supreme Court in the Antonyuk case last year, wanting to block what the Second Circuit had done. The Supreme Court, on review of that emergency application, denied relief but stated that the Second Circuit could not simply drag their feet on the issue. They needed to either expedite review in these cases or write an opinion justifying why they issued those blanket stays. The Second Circuit, not wanting to justify those stays, decided to expedite hearings in these cases.
in effect, banning, or at a minimum, severely restricting
figures. And this is something that we should celebrate, that today's gun owner is looking a little bit less like me and more like the rest of America.
The limited exemptions are negligence, knowingly selling to somebody who's not allowed to have a firearm.
Roughly 40 million firearms with stabilizing braces in circulation to obtain a special registration.
Concealed carry law in Antonyuk case. The big argument really came in the Antonyuk case because it presents a comprehensive challenge to the CCIA. It challenges the permit process required to obtain these new permits and also contests several location restrictions. Ultimately, the Second Circuit vacated some of the district court's injunctions, which had halted the enforcement of the CCIA. In their decision, the Second Circuit distinguished Bruen as an exceptional case. Consequently, the Second Circuit vacated much of those district court injunctions, finding that virtually all of the CCIA is facially constitutional under the Second Amendment. The Second Circuit believed that the CCIA was permissible. In response to the Second Circuit's rulings, GOA has now filed a petition for Supreme Court review. Although this case is still technically in an interlocutory posture, it involves a review of the preliminary injunction and what the Second Circuit said about those preliminary injunctions. This case directly results from what the Supreme Court said in Bruin and what New York did in response to that decision. In their petition, GOA notes that there are significant differing views over the kind of historical evidence suitable to sustain legislative limitations like the CCIA following Bruin's ruling. Some courts, like the Second Circuit, continue to permit later historical support and have even gone so far as to challenge what the Supreme Court said in that ruling.
New York lawmakers have approved a sweeping overhaul of the state's handgun licensing rules.
Into law, it would forbid, make illegal any FFL in the state of New York.
The new rules mean for New Yorkers and how the state's governor is vowing to fight back against other controversial decisions.
Just to throw a little sugar on top, they would give unfettered discretion to your state police to figure out what really is an appropriate.
Really made America a very dangerous place, particularly in New York City.
We want a shooter to have to go through multiple steps in order to be able to fire the weapon.
GOA states in their petition that the panel repeatedly advanced the remarkable theory that it was not bound to apply the court's methodology in Bruin, labeling Bruin a case of exceptional nature. The panel surmised that courts are not required to follow Bruin's lead in cases challenging less exceptional regulations. The panel repeated this claim no fewer than 4 times, each time justifying circumvention of a portion of Bruin's framework on the theory that Bruin came out the way it did only because it was exceptional. They point out that the Second Circuit said they did not have to follow Bruin because Bruin was an exceptional case dealing with an exceptional regulation. They argue that the CCIA is not exceptional and is not a similar type of regulation to what was addressed in Bruin.
In most public places, even with the concealed carry permit, is now in effect, even as the case makes its way through the courts.
And I was sharing with you my knowledge of a program in which ATF has defined this term.
Analogous historical tradition of regulating weapons that would make an assault weapons ban.
Where they were labeling their weapons. Would there be a label on the wall for assault weapon?
I want to be clear, this wasn't based on violence. This is based on threats specifically to individuals, on gangs.
We can expect in the future that more people will be carrying handguns on the streets in places like Los Angeles, Boston, and New York City.
The outcome of Antonyuk is very important for people in states like California, which are facing similar concealed carry restrictions passed after Bruin. For instance, California passed SB 2 in response to Bruin. The lawsuit is currently under review by the Ninth Circuit Court of Appeals, which recently held arguments in this case. What's interesting is that they asked, why wouldn't we just follow what the Second Circuit said in Antonyuk? The state of New York now responds to this petition by arguing that the Supreme Court should reject the review of this case outright, citing that it is a preliminary injunction review and that there are currently no circuit court splits on the matter. The state of New York further contends that the petition for certiorari should be denied as a preliminary matter. Preliminary injunction in licensing case. In this case, where the Court of Appeals merely determined that the plaintiff did not establish a likelihood of success on the merits at the preliminary injunction stage, either for a lack of standing or for a lack of meritorious legal claim, this court's custom of refusing interlocutory review is especially advised. The preliminary injunction record was created in a few short weeks, and no fact or expert discovery has been conducted as of yet. This may obviate any need for this court's review. At a minimum, such review would be aided by a complete record and merits determination. New York is essentially trying to kick the can down the road, suggesting that the Supreme Court should not review the case right now, as it is at an early stage. They argue that it should be sent back down to the lower court for an actual merits decision where more evidence can be gathered. At that time, if the outcome is unsatisfactory, the Supreme Court can step in. New York goes on to state in the response that no petitioner has applied for a license under the challenged licensing scheme, much less been denied a license based on the good moral character requirement.
And no one contends otherwise, but what are the limits? Wouldn't it be nice to hear?
It requires agencies to submit a rule to Congress before the rule can take effect. After submission of a rule by the agency,
or policies as before us today to make it harder for law-abiding citizens to obtain firearms.
Year-old adults guns that are in common use. It bans for everyone.
And yet at Uvalde and in so many other school shootings, we were not willing to protect our children.
There is no record supporting the petitioner's speculative assertion about the license review and adjudication process. The state of New York is pointing out that, in their eyes, there is an issue of standing. They suggest that standing has not been met because the individuals involved have not actually gone through the process to be denied or approved, or specifically denied based on good moral character. This issue of standing was brought up earlier in this case and in some other related cases. Initially, it was believed that there was no standing for some of the claims. Although this was resolved in the lower court, New York is raising it again, suggesting that there may be no standing to challenge the process since none of the individuals have actually gone through it. Now, the Supreme Court will decide whether to grant review to this case, even though it is currently in an interlocutory position.
Are ones where, in fact, it's most likely that they should be bringing the highest and mandatory minimum.
Details of the law, but folks, listen at home. Here's a quick summary of what this law is doing. It's already allowing.
Might end up being a message amendment because the President of the United States will almost assuredly veto it.
The Supreme Court has now distributed the Anonio case for the June 6 Supreme Court conference. At this conference, the justices will convene and ultimately determine whether they wish to grant review to the case. Although the Supreme Court typically disapproves of preliminary injunction reviews, this particular case is so closely related to the Brunner decision that it may be worthy of review. Currently, only 4 justices of the Supreme Court are required to genuinely want to grant review to a case. This might be accomplished by convincing Justices Thomas, Alito, and 2 other judges to agree to hear the case. Either way, this situation will be closely monitored. That's all for this video, folks. See you next time.